Hello and welcome to Case Closed. I'm Charlie Langton, your host. Today we'll go inside an actual courtroom in the Warren District Court to see real small claims cases in action. Under Michigan law, small claims cases may be brought by individuals seeking $3,000 in damages or less. Neither side may be represented by an attorney in small claims court, and the judge's decision is final. Now, let's take a look at the first case of the unpaid lawyer.
District Court is in session. I will Judge Schmer presiding. Please remove your hats and shut off your cell phones.
Tell me what you're here for, Mr. Bronca. Go ahead.
Your Honor, this is a case for unpaid attorney's fees. I represented Ms. Garncars in an action in Iosco County, and she owes me a balance of $1,327.37 plus cost of $88 for a total of $1,415.37. This balance has been outstanding since 2002.
2002?
Yes, Your Honor.
Now, $1,327.37 for unpaid attorney fees. This was for an action that you represented her in 2002, then you said?
Yes, Your Honor.
What type of case was that?
It was a partition action in Iosco County.
Okay. You have a retainer agreement I see that's signed here by you and your former client, I guess.
Yes.
Signed August 27th, 2001. Is there an hourly rate on here? It's kind of a hard copy for me to tell.
The hourly rate.
Oh, $135 an hour.
Yep.
Okay.
Your Honor, if I just, she might, that was the original retainer agreement, and then after a little bit of litigation, she wanted, in order to pursue it, she wanted, we entered into a separate agreement. The amount that I'm claiming is for the balance that was owed before the second retainer agreement was signed.
Okay.
So,
did she give you a down payment at all?
yes, she did.
Okay, so this is the balance of what's owed.
This is the balance, yes.
You were paid something.
Yes, oh yes.
All right, well, Ms. Garncars, what is your story here?
Yes, I agree that Ms. Sabraka represented me once. I paid her a retainer fee, and then the second time I paid her another retainer fee. Over a year had gone by before we actually had a court hearing in Iosco County.
Okay.
Okay, which is a lot of time that had gone by.
Well, not necessarily. I mean, you know, courts don't move very quickly, ma'am.
Well,
even in Iosco County.
Her letter is dated September 17th of 2002, in which number one said she'll be, if client is awarded title to property, okay, subject property that is in question or was in question. And then number four says client grants attorney an attorney lien against the property located at wherever that was to secure payment if client is awarded title to the property. I was never awarded title to the property.
Was that part of the retainer agreement?
Yes.
The lawyer is suing her client for not paying her attorney fee. The client says, I didn't win the case. The issue for the judge is whether the lawyer should get paid for the job or for the result.
Why did you sign a second retainer agreement?
That was a mistake on my part. Big mistake.
I guess so.
All I'm asking for is what she owed me on the original. This was an outstanding invoice dated September 3rd, 2003 that predates that retainer agreement.
Well, I guess the question is which retainer agreement applies.
The original retainer agreement applied up until September 17th when the new retainer agreement was signed. And these are for, or what I'm asking for are services that were provided prior to the September 17th date.
But there's no, is there a contingency on here that you're paid only if she's awarded title to the property? And that retainer
further
agreement,
attorney's fees. Yeah, any further attorney's fees.
Where is that? What paragraph is that?
It says further compensation, I believe.
Attorney shall be entitled to further compensation only if the client is awarded title to the property located at 205 Harbor Street, Oscoda, Michigan.
Right. Further compensation.
Okay, so this is additional fees that you would be entitled to if she was awarded title to the property beyond what would be owed under the first retainer agreement.
Because there was additional time that was going to have to be put into the matter, and she didn't know if she wanted to go to trial, and she was...
Now, I have a copy of the first retainer agreement here, but it's very hard to read. It didn't copy well at all. Do you have a clean copy, something I can look at? Does it contain an hourly? Yeah, I guess it does
Yes,
have an
it does.
hourly rate on it. Again, $135 an hour.
But I have I have a bill that details the dates and the time spent
Okay.
up to that
Why
point.
don't you give me that, and do you have like I said, a clean copy
Yes.
of that first retainer agreement? Let me take a look at that, because this copy here is like almost worthless. Okay. Oh, it's a lot longer than what you have attached to the file. Well, now I'm even more confused. Because what you have in the file here is nothing even close to what you've given me. This is a 3-page retainer agreement. This is different than what's in the file.
Applied that.
I don't think you have.
Or if it was applied by Ms. Garnkars.
All right, let's take a look at this. What you're giving me is the first retainer agreement then, right?
Right.
Okay. This agreement is made on August 27, 2001 between you, Josephine R. Sabrok, attorney, and Fran Garnars, the client. And it says that you're going to be retained as Ms. Garnar's attorney to represent her related with an action to quiet title. Okay? Fees, $135 per hour. And there's a lot of other verbiage here that's standard stuff that I'm not going to go into. And you have also given me an invoice that shows statement of services rendered, the date, description of services provided, and the time. And it totals $1,327.37. That's what you're suing to collect today. You haven't been paid any of that then, apparently.
No.
She did originally pay you, looks like $873.25 at some point.
And that's more than, there were a couple of invoices, so the
Right.
total was more than that.
The total is $2,200.62. And she paid you $873.25, leaving a balance of $1,327.37. And that's how we get to where we are. Am I correct, Ms. Sabraka?
That's correct, Your Honor.
All right. And then you, by mistake, apparently, on September 17th, 2002, about 2.5, 3 weeks later, signed an amendment to this retainer agreement saying that you would only be entitled to further compensation if the client was awarded title to the property, which didn't occur, but instead she got $50,000. And that's your defense, right, Ms. Garnars? That you should have to pay anything because you never were given title to the property.
Correct. I'm contesting it due to that fact, and also because there was no judgment posted for the judgment. There was
But
no.
you got $50,000.
The judgment was not posted, okay?
What do you mean it wasn't posted?
Ms. Sabraka just dropped out. She said she wanted out, okay? The $1,300 and whatever, I don't recall owing her due to the fact that we made an agreement that if title wasn't received for the property at that hearing, that I would not owe her anything.
A retainer is a contract between the attorney and her client. There are two types of retainers. One is for hourly, the other one is a contingency. And that would mean that if you win, you get paid. In this case, there are two retainers. And the decision for the judge is which retainer or contract applies. Let's see what the judge does after this break.